My lady, if I may, I'm just going to make one final submission on the point that we were just dealing with.
Yep.
And then I'm going to deal with my Lord Justice Arnold's questions about the computer. And then, subject to any further questions from the court, I'd quite like to move on to the next part of the submissions, if I may. So the last point I just wanted to make on the issue of the whether you can decompose an ANN into a program and a computer is just here to pick up again that the operation ANN is fundamentally different from what you call a classical computer program, not only in the lack of a series of instructions, but also in that, as I've already explained, such function is present in the device is not one that's defined by a programmer. That's the intractable problem point which I mentioned earlier. And as I said, in most cases, which this is one, with an ANN, the human has no idea how to address a problem, let alone write a series of instructions to solve it. And as I've submitted, the term instruction is one freighted with telling the computer what to do. At most, the human is involved in setting the parameters for the training program, and we do accept there's a program involved at that stage. But once you turn to consider the final ANN itself, the human is not involved. And, sorry, the human does not instruct the trained ANN what to do, or even attempt to explain to it, or tell it how to solve the problem at hand. I was then going to just address computer program and computer, if I may. A computer program, my lady, my lords, our submission is that that should be construed as was discussed in Gale, which is referred to in our skeleton argument at, I think, 34. Namely, a series of instructions being capable of being followed by a CPU to produce a desired result. So that includes...
So it's implicit in that if you've got no CPU, you've got no program.
If you haven't got a central intelligence, instructions for a central intelligence, then you don't have...
No. That requires the presence of a CPU. So any computer which doesn't have a CPU, you're out.
My lord, indeed, that is what I've said. Now, the concern I have is that my lord is going to say there exists something that is a central intelligence in a computer of a type like a CPU, which takes in instructions, performs processing and spits out instructions, which has a different acronym but is functionally the same thing. I am afraid, and we were discussing this over lunch, that I am not aware of something like that. So maybe instead of CPU, one would say a similar central intelligence to the device, but we are talking about something that is akin to a CPU and not a diffuse network, for example, as you find in this case. So
what I'm trying to understand is what is it that characterises what you're trying to explain? And at the moment, what it sounds like what characterises what you're trying to explain is something that does things in a sequence. And what I'm bothered about is that would mean that a parallel system in which you had lots and lots of little brains which operate in parallel wouldn't satisfy your definition, even though I think everyone would regard that as a computer.
What I'm really trying to get at is the concept of having a particular unit, in my lord's case, a series of a particular thing which is akin to a chip, which takes in a series of logical instructions and performs.
That's why I said, well, that's exactly why I said what I said, because you said the word series there again. And what it sounds like, well, that's what you mean. But I'm not trying to put words in your mouth, Mr. Taxman. I'm trying to understand what you're saying.
My lord, it's my submission.
Okay.
And a computer is a computer as per the judgment in 39, where you'll see what it states, because there is just a point I wish to make, which is where it says an electronic device, etc., and processing it in accordance with variable procedural instructions, brackets, programs, or software. There we would take that to the description of variable procedural instructions, programs, or software to incorporate the Gale definition that we just discussed. So that essentially incorporates the existence of, as Mann has just said, a CPU into that definition.
I don't know what you mean by, as I just said, I have to tell you, but I don't think we don't need to debate it.
in what you might call a typical computer, there exists a collection of hardware pieces, buses, memories, printers, output things, but you tend to have a central, in a simple computer, a chip, which is the intelligent part of the computer that processes, serially in this case, instructions. It processes the instructions. And when I refer to a CPU, or a CPU with a similar central intelligence, what I'm trying to get at is you have something that processes a series of instructions. Now, you could have a series of instructions which are sent individually to a plurality of these things. They're still processing a series of instructions, and they may be cooperative because you can have multi-processor chips, things like multi-processor computers and things like that. But what I'm trying to get at is, in essence, that they are processing instructions of type that a typical computer programmer, C or whatever, would be writing. And what I'm trying to get away from, what I'm trying to capture, is a kind of diffuse, just electronic network which has a function. And I appreciate trying to do this on my feet, that there are corner cases that problem is I'm not even aware of them before my Lord raises them. And so I'm trying to shoot down things I'm not aware of. But what I'm trying to get at is a computer which has a central intelligent unit which processes instructions and then operates accordingly. I was going to move on if I may.
Yeah.
The next point we come to is, assuming I'm wrong on that, and the judge is wrong on the point we've been discussing, is there nonetheless a technical contribution? As I explained to my lady and my lords at the outset, there are three ways we put that case. Now, we have a broad criticism of the way my learned friend approached this in his skeleton, which one sees particularly, for example, at 32 to 34 of his skeleton. And if I could ask my lady and my lord to have a look at that. What you see here is in 30... Sorry. What you see is in 32, he sets out the components of the system to which claim 4 relates. It refers to the data files, target data communications network, as well as the ANN, etc. In 33, he then goes on to say everything in the system apart from the training program is already well known in the art, and says it's not particularly taught to. And in 34, he says, accordingly, once the claim method is stripped, as it must be, of its form, the characters which are common to any or at least most ANNs and the network and the media file database and the user device, all of which are known in the art, all that is left is the training process, that is in substance the contribution of claim 4. And we say that approach is the wrong approach. And we address that in our skeleton from 35, where we discuss Aerotel. And my learned friend hasn't addressed my lady, my lords, on this point. But some of his submissions are inherent in some of his submissions is his process of drawing out that which makes the claim inventive and focusing on that. Now, could I ask my lord, my lady, also to take up Aerotel itself, which is in the Authorities Bundle, tab 4. And I'd like to start in paragraph 78, which is page 68 of the bundle. You may recall this is the case where Lord Justice Jacob, on behalf of the court, set out an analysis of the law sort of towards the back of the judgment. So the court there starts by setting out the approach of Falconer J and Merrill Lynch. And you see there's a quotation from Falconer J at the end of paragraph 78. And there he says, in my judgment, when invention is sought for any excluded matters, on its proper construction, the qualification section 1.2 does require the Patent Office an initial inquiry and assessment as to whether the inventive step resides in the contribution of excluded matter. If only the contribution of excluded matter is an inventive step, invention is not patentable, etc. And so there, what Falconer J was focusing on was the inventive step and whether that inventive step was within the exclusions discarding everything else. And in my submission, that is closely akin to what my learned friend does in his skeleton at 34 we just looked at. And also, just for your note, paragraph 55 is another example, and there are others. Now, then reading in Eretel 80, here the court introduces the decision in Genentech, the decision of the Court of Appeal in Genentech, which my lady and my lords will recall was an early decision in the field of biotechnology, and which raised arguments, amongst other things, about whether there was an invention at all. And as is set out there, the Court of Appeal noted a distinction between Falconer J's approach in Merrill Lynch and the approach of the EPO in Vicom, which we'll come to look at shortly. But one of the main paragraphs in Vicom, paragraph 16, is set out under paragraph 81. And in fact, that's one I summarised earlier. And there's two important points to come out of that. Firstly, the mere fact that a computer is used to implement the invention is generally no objection under the exclusions. But second, what is decisive is the technical contribution of the invention as defined in the claim when considered as a whole. One has to consider the claim as a whole. And that distinction between considering the claim as a whole and its inventive step is what the court focuses on in this judgment. So now in 82, the court sets out one of the problems with the contribution approach of Falconer J, and they're citing Lord Justice Dillon in the Court of Appeal and Mr. Justice Whitford in Genentech at first instance. And then at 83, the court says, given what's said in Genentech, it's hardly surprising that when Merrill Lynch reached the Court of Appeal, the reasoning of Vicom was preferred. The technical advance or technical contribution test of Vicom was adopted, and then it quotes Lord Justice Fox, who then essentially recites what's in Vicom. And as the first sentence of 84 shows, it says, thus it was that the court adopted the EPO's technical contribution approach, and then it goes on to consider what's known as the rider. I don't think the rider matters for today's purposes. If one can then, sorry, I'll pause a minute. If one can then turn back in the bundle to page 57, it's paragraph 26. There, Lord Justice Jacobs sets out the three approaches which are seen in various strands of case law. The first is the contribution approach of Mr. Justice Falconer and Merrill Lynch, where you ask whether the inventive step resides only in the contribution excluded matter. But as the court sets out there, this approach was supported by Falconer but expressly rejected by this court, and there they're talking to either the Court of Appeal decisions in Genentech and Merrill Lynch itself. Second is the technical effect approach, where one asks whether the invention as defined in the claim makes a technical contribution known to the art, subject to the rider. So there one is focusing on the invention as defined in the claims, not just what makes that inventive itself. And third, we have any hardware approach, which is the approach that's in fact taken in the European Patent Office, but we don't need to get into that one now. That then takes us to the Aerotel questions themselves, which are found in 40 paragraph. Sorry, they're discussed in our skeleton 44 to 49. And if I could ask my layman to have a look at those. Let's try and short circuit matters slightly. So in 44, we set out the test, the four-stage test. The second step is in paragraph 45, and that is simply to construe the claim. Third, we have to properly characterise the claimed invention as a whole, taking form over substance over form, etc.
So which of the four questions in Aerotel is that?
This is the second step to identify the contribution.
Right. And where do you get that from Aerotel?
Sorry, where do I get? You have to. Step two is.
Because you seem to be rephrasing what's in Aerotel itself.
Because
if we look at Aerotel itself, which is accepted by both sides to be binding authority, which we should follow. Paragraph 40, we get the four steps. Step 2 is identified by the actual contribution. And then the second step is addressed at 43, which is where they say, how do you assess the contribution? Mr. Birss submits the test is workable as an exercise of judgment, probably involving the problem said to be solved, how the invention works, what its advantages are, what has the inventor really added to human knowledge, perhaps best sums up the exercise.
Sure. So the second,
and they finish by saying it looks at substance, not form.
Sure. So sorry, the second step is an identification of the actual contribution.
Absolutely.
And the third step is asking the question of whether that contribution falls solely within excluded subject matter.
Yeah.
Okay. And there is where my Lord Justice Birss, as well at the bar, set out that very well-known passage.
Well, what I've just quoted is about the second step, not the third step.
Sorry, I may be misunderstanding. I think I thought
it helps if you look at what Aerotel says rather than at your paraphrase of it.
Well, my Lord, it was okay. Certainly, my Lord. What I thought my Lord was referring to was paragraph 45.
No, I was quoting paragraph 43.
So of Aerotel on my skeleton.
No, of the actual judgment.
Yes. Okay. So the second step Sure. So, my Lord, I'm obviously being dense. I am only trying to set out what is in the Act. So the second step is to identify the contribution. And there, my Lord Justice Birss set out the passage about involving a problem to be solved, how the invention works, what its advantages are, etc., which we set out in our paragraph 46. And then the third step is addressed at 45 in the judgment.
Indeed.
And is set out in 47 of our skeleton argument in turn.
Right.
And then obviously the fourth step is at paragraph 46 of the judgment, but the rider we haven't really focused on because it doesn't seem to really add much. So in the second step, one looks at this multifactorial analysis that you see in paragraph 43 of the judgment and asks, for example, what the inventors really added to human knowledge, perhaps sums up the exercise. And the formulation involves looking at substance, not form, etc. And then the third step is the one in 45 of the judgment, where during the course of argument, Mr. Birss, as he then was, accepted a reformulation of the third step, asked whether the contribution thus identifies consistent with excluded subject matter and such, and such. So that is the test. So I was going to make two further points on this. So, Manuel, has that addressed the point you were raising? I apologise, I have not understood that.
Well, because what you seemed to be doing was making a submission which involved a paraphrase or reformulation of the second step in error tell. And maybe that was intentional, maybe it was unintentional, but I was just trying to focus on the language of the judgment.
Sure, my lord. I was not seeking to reformulate that test at all. I apologise if I gave that impression.
Very good.
Indeed, of the 2 points I wanted to draw from this, my first one is that it's important that you treat separately the steps of identifying the contribution in the second test and then identifying whether that is solely lies in an excluded subject matter as such in the third test. And it sounds like in my submissions I fell into the trap that I immediately was about to tell my lord that my lord shouldn't do.
It's easily done in this field.
Oh, it's very kind of you. But for example, a floppy disk or a computer is plainly a physical technical thing, and that's one of the comments that's made frequently in the cases. But it's not normally enough to claim a program on a floppy disk or a programmed computer, since a floppy disk and computer is not normally fairly included as part of the contribution, not because it's not technical. And that sort of brings us to the question of how one identifies what the contribution is. And this is where I part company with my learned friend in his paragraphs 32 to 34. Because in our submission, this part of error tell plainly has to be understood in the context of the decision as a whole, and particularly including the discussion of Merrill Lynch, Genentech that we looked at a few minutes ago, and also the paragraph 26 we saw just after that. What is required is a consideration of what the invention claims taken as a whole. It's likewise clear that the process is most definitely not one of extracting the inventive step from that which is old or obvious. That's the contribution approach. It's also not enough in this jurisdiction that the claims merely recite the presence of some hardware. That's the wrong approach, but the other end of the spectrum. And in a sense, the technical effect approach is seeking to draw a path between the Scylla of any hardware and the Charybdis of the contribution approach. But as I said a moment ago, it's important to understand why the any hardware claims fail, at least in my submission. And it's not because the floppy disk or whatever is not technical, because it's a piece of hardware. The problem for such claims is that the hardware forms no part of the contribution of the claim considered as a whole. And in an any hardware case, the hardware simply forms a medium for doing its normal job, just storing instructions. There's no real interaction between the hardware and the series of instructions of the computer program it stores, save for the mere storage. It makes no real difference to the invention on what medium it's stored. And it makes no difference to the medium, what instructions are stored or recorded upon it. So in such cases, it's fair to describe the contribution as just being the computer program. But can I take a different case? Such as where the computer program or algorithm is crafted having specific regards to the features of the hardware. If you have, in a case like that, the hardware it will obviously depend on all the facts, but the hardware may properly be described as part of the contribution, even though it's not inventive in itself, and the whole claim can therefore become patentable. And if I could take my lord and my lady to the EPO guidelines, which my learned friend put in the bundle, they're in Authorities 25, and it's page 556. Now this is part of the guidelines relating to the mathematical exclusion, but in my submission they're informative of the thinking nonetheless. So it's page 556 in the bundle, it's tab 25. And it's the bottom paragraph. So a mathematical method may also contribute to the technical invention independent of any technical application. when the claim is directed to specific technical implementation of the mathematical method, and the mathematical method is particularly adapted for that implementation, and the design is motivated by technical considerations of the internal functioning of the computer system or network. This may happen if the mathematical method is designed to exploit particular technical properties of the technical system on which it's implemented to bring about a technical effect, such as efficient use of storage cost or bandwidth. For instance, the adaptation of a polynomial reduction algorithm to exploit word size shift, match the word size of the computer hardware is based on technical considerations, can complement producing the technical effect, etc. So what you're seeing there is claims may be allowable even independent of any wider technical application, where the maths is tailored to the specific hardware. Now, they don't phrase this quite in the way I was talking about it, my lords, because they don't approach exclusions in the same way. But when you look at our approach to exclusions, in my submission, what one would say there is, in a case like this, there is, when defining the contribution, a nexus, a suitable nexus between the program and the hardware that's storing it or underlying it. In that case, you could describe the contribution fairly as being the computer and the related hardware. And in that case, you then have hardware as part of the contribution, the inventive contribution as a whole, even if that hardware isn't inventive in itself. And that claim would be outside the exclusion. And now, if I can take a yet further example, which is further from any hardware, such as the alert message in protecting kids itself. Excuse me. If one looks at the alert message in protecting kids, or the data transfer in Gemstar even, they were not themselves any part of the inventive step. The transfer and message were part of the claimed invention, however, or the claimed contribution, because they occurred because of other parts of the invention, and their content and existence were dependent upon and interacted with other parts of the invention. And I have to come back to protecting kids later, but if I can show my lady, my lords, how Mr. Justice Floyd, as he then was, put it in protecting kids. That's in the Authorities Bundle at 9, and it's page 226 of the bundle. And just for context, what happened here is there was a claim 20, which claimed the clever bits within of what's known as packet sniffing within the computer. But claim 33 added to that the sending of the external alarm message. And what Mr. Justice Floyd said is, in the context of the present case, I would hold that the contribution made by claim 33 includes, in addition to features identified by the hearing officer, which was the message, the generation of a more rapid and reliable alarm notification. Viewed in this way, although at a high level of generality, alarm notifications were not novel, the particular alarm notification described in the specification claim 53 was not known and formed part of the contribution to human knowledge made by the application. So here, although Mr. Justice Floyd explicitly recognised that the alarm notification in itself was not new, he said that because of the relationship or interaction between this alarm and this computer program stroke alert system, the messages were new and different. They had a different content, they were more reliable and more rapid. And as such, they form part of the contribution of the claim as a whole. And in my submission, Mr. Justice Floyd absolutely correctly applied the proper approach to identifying the contribution in accordance with Aerotel. And also it shows how that leads one to navigate between the Scylla of any hardware and the tributus of the contribution approach. And the position is similar also in Gemstars, and we'll come on to, which is the transfer of data there was not new, and it was not any part of the inventive concept. The manner of the transfer, in particular in terms of its triggering and its content, were held to be, or considered to be, sufficiently closely related to the other integers of the invention that the transfer formed part of the contribution as a whole. And so, in my submission, those are clear examples of why the approach of saying I'm going to focus on inventive step is wrong, and these are clear examples of how to do it right, as it were. Now, with that, I was going to move from Aerotel and have a look at Vicom, unless there are any further questions on that. So, Vicom. Now, Vicom it's in the bundle.
Can you explain to me why we're looking at Vicom, given that we're bound by our own authority, and the EPO left Vicom behind eons ago?
Sure. The point about, well, Vicom has a few things in it. It partly deals with the mathematical exclusion, which I was going to pick up, but dealing with the more substantive points.
Let me put the question a different way. Either Vicom was correctly interpreted in Aerotel, in which case it adds nothing, or it was incorrectly interpreted in Aerotel, in which case it's irrelevant.
Okay. The thing about Aerotel, and this is mentioned in my skeleton, is it correctly orientates the court to ask the question of, is there a technical effect? But it doesn't really help identify how one answers the question of whether there is a technical effect. And this is a point that Lord Neuberger made in Symbian, I think it was 9 and 12. So if you get, so what you do...
Maybe we should look at Symbian then.
Well, Symbian just says it doesn't really tell you the answer. Aerotel doesn't really tell you the answer to that question. And that's why in my skeleton I say it orientates the court. But it doesn't really answer the question of is how you assess there's a technical effect. And that's what Vicom is referred to, and in many, many English cases. And my lord, you are right that Vicom, that the EPO has moved on in terms of how it approaches excluded subject matter. But Vicom is still referred to extensively in the, for example, the EPO case law book, as how one approaches a question of technical contribution, but albeit in the convict context. So it's not that Vicom has been abandoned in the way it approaches technical contribution at all.
All right.
So Vicom is at 13 in the authorities bundle, page, and if we start at page 317. Sorry, we start at page 321, actually, OMA. And just very briefly at the bottom of the page, there's a paragraph saying digital filtering. So this is how the applicant themselves characterise their invention. It's digital filtering in a general, digital filtering in general and digital image processing in particular are real-world activities that start with the real world with a picture and end the real world with a picture. And what goes on between is not an abstract process, but then physical manipulation, electrical signals, etc. And the reason I point to that is because in Vicom, the analysis of a digital file and just the presentation of that analysed digital file on a screen at the end of the process was considered technical as a whole. Just wanted to make that point on the facts. The claims are set out in the bottom of section of page 322. The text is a little dense, but what one sees is that the claims are directed to methods and apparatus which are defined substantially by the mathematical or algorithmic approach which they take to image processing. So it's absolutely paradigmatically a case that's implemented in accordance with an algorithm executed on a computer. In paragraph 3, which is on page 324, the board considers industrial application. And if my lady, my lords, could just look at the first two paragraphs of that. Because there the board held that obtaining and reproducing an image gives the invention industrial application even where the image is virtual, such as a CAD design. And the reason I flag that is because that's got some similarity with how my Lord Justice Birss approached matters in Halliburton, where the method was for CAD design of a drill bit, but the manufacture of the bit itself wasn't claimed. And then in 4 through to 6, there's a discussion of the mathematical method exclusion. And to save coming back to it later, if I could ask my lady, my lords, to just read paragraphs 4 through to 6. So the point the board is making there in respect to the mathematical exclusion method is that the use of a mathematical method in a technical process, which itself is not within the excluded field, I would add, is technical and outside of the exclusions. And we'll come back to that later, but I just wanted to pick that up while we were open. Now if one, from paragraph 10, which is page 327, the board starts to consider the exclusion in respect of computer programs. So in 11, the appellants point out that the application discloses new hardware for carrying out the claim method, but admits, on the other hand, that at least in principle it's possible to implement the method and apparatus according to the application by a suitably programmed conventional computer. So this is a case where you can have a specialist hardware implementation or implementation here as a classical computer program on a conventional computer. And then in paragraph 12, it says the board is of the opinion that a claim directed to a technical process, which process is carried out under the control of a computer, cannot be regarded as related to a computer program as such within the meaning of Article 52.3 BC, as it's the application of the program for determining the sequence of steps in the process for which effective protection is sought. And what they're saying there, and we set this out in Article 52, a technical process controlled by the computer is not within the exclusion, since the role of the computer is merely to implement the process, what it describes as the sequence of steps in the process. But it's the process which is claimed. And we'll pick up on that when we get down to 15 and 16. But in 13 and 14, the board considers an objection for lack of novelty, saying that the mere fact the invention may be implemented on a standard computer is not problematic. A standard computer set to operate in a new way cannot be seen as part of the state of the art. And then one gets at 15 and 16 to the key passages, which are the ones most commonly cited in both the European and the English authorities. So it says, and apologies for reading it out, but in view of certain considerations by the examining division which appear to apply to apparatus claims as well, CF paragraph 10, it remains to be examined to the present apparatus with rejection under the Article 52.2c. The reasons analogous to those given at paragraph 12, the board holds this is not the case, and saying can be applied to other claims 9 and 11. Then it says this, generally, claims that can be considered to be directed to a computer set up to operate in accordance with a specific program, whether by means of hardware or software, for controlling or carrying out a technical process, cannot be regarded as related to a computer program as such, and so are not objectionable, and thus are not objectionable under Article 52.2c(3). And what the board is getting at there is that if an invention is one which is agnostic of the exact manner of its implementation, then generally it will not fall within exclusion, since it will be properly to be characterised as a claim to that invention at that level of generality that's above and agnostic of the mere manner of its implementation, whether that be by a computer program or not. So that's just, in effect, saying focus on the invention at the level the invention is cast. And it also makes the point that similarly or accordingly, it's no objection the invention can be implemented as specialist hardware or on a conventional computer. That doesn't matter. And then in 16, in arriving at this conclusion, the board has additionally considered that making a distinction between embodiments of the same invention carried out in hardware or software is inappropriate, as it can be fairly said that the choice between these two possibilities is not of an essential nature, but is based on technical and economic considerations which bear no relationship to the inventive concept as such. So that's much the same point again. And then, generally speaking, an invention which will be patentable in accordance with conventional patentability criteria should not be excluded from protection by the mere fact that through its implementation, modern technical means of forming a computer program are used. Decisive is what technical contribution, the invention as defined in the claim, when considered as a whole, makes to the known art. So from that I draw 4 propositions in Viking, which we see reflected in many of these other cases. Firstly, it requires a consideration of the claim as a whole. Secondly, an invention which will be patentable in accordance with conventional patentability criteria should not be excluded from protection by the mere fact that its implementation uses a computer. So accordingly, a computer running a program directed to a technical process is not within the exclusion. And finally, fourth, it's no objection that an invention can be implemented as specialist hardware or on a conventional computer. That doesn't matter. The reason it doesn't matter is the invention is cast at a higher level of generality than its specific manner of implementation. So that takes us to the question of identifying the technical effect, or whether the invention contains technical features, it's sometimes put. And the conceptual point is really this, which underlines this analysis seen in Vicom and in other cases. The statute does not exclude a claim which relates to or uses a computer. To the contrary, it only excludes inventions which a computer programs as such, or as it's sometimes put, only resides in excluded subject matter. So if, therefore, the invention is properly characterized as a method or apparatus for doing a particular something, then it's not a computer program as such, but is a claimable invention, unless that something itself is excluded. And that's true even if the entirety of the invention is implemented on a computer, which was the case in Vicom. And there's some of the other cases like Aerotel and I think AT&T characterize the invention as Vicom as an improved method for analysing files, visual files, image files. But it's all on a computer, but it was still claimable.
Yeah, it was image processing, so you got a sharper image.
But it was only a presentation on the screen that ultimately is all you got. So that here the invention is properly characterised at a higher level than the manner of its implementation on a computer. And this is the kind of invention we mentioned in, if I could ask you to turn to this just for context, in 67A of our skeleton argument. It's page 70 of the bundle, 17 of the skeleton. So that's 67A, and as we note in C, there's also what are known as better computer cases, but probably, in my submission, those are basically best defined as just a subclass of the first class, because in those cases the invention is an improved computer. Now in the cases, one also finds a second class of cases where a technical effect is demonstrated. And these arise where where some integers of the claimed invention may properly be characterized as a computer program, but other integers of the claim are wider than that and contain other features which are not within the exclusions. And so the claim as a whole is not within exclusion. These are the ones we address in 67B, and that includes, as we'll come on to see very shortly, Gemstar and protecting kids, but we also there refer to Halliburton as well. Now, and sort of conceptually, in my head, I view the first class, the 67A class, as ones where the invention is above the level of the computer program. And the second class are ones where the invention is wider than just the computer program. And obviously, there may be interactions. So, Mr. Justice Floyd put it both ways when we see it in protecting kids. Now, in this, we mention in 67A certain cases like CFPH, AT&T, and Halliburton. I'm not proposing to take my lay, my lords to those because time doesn't allow, and there is some interest in them, but I think there's more efficient things one could do unless you wish me to go there. I was instead going to turn to the external technical effect type cases, my 67B cases, and address you on Gemstar and protecting kids. Gemstar is in authorities at 7. And my lady, my lords may recall that this is a case which involved 3 patents. The first 2 involved only displays of information on a TV screen using an EPG, what's called an electronic programming guide. But the third was different in that it involved, in addition, the transfer of a recording of a TV program onto what was referred to as a second storage medium. And it was therefore referred to in this case as the transfer patent. And if we could start at paragraph 7, which is page 138 of the bundle, please. So paragraph 7. So you see there, the transfer happens because the user chose the particular program in question using an EPG, and that caused it to be stored on the secondary storage medium. But as the judge also notes, the secondary recording process was not said to be invented. What was said to be invented was the process of selecting the program by using the EPG to do so. Now, the judge held the first 2 patents to be invalid, amongst other reasons for falling within the exclusion for computer programs as such. And he did so on the basis that the mere display of information on a computer screen was not a technical effect sufficient to escape the exclusion. So he said that was a very common feature of computer programs, and so was not enough to constitute effect outside of the computer. That, you'll note, is 50 for the first patent of the judgment and 147 for the second patent. But he also held those patents to be excluded as mere presentations of information too. And again, for your note, that's paragraphs 52 and 148 respectively. But if I could take my lady, my lords, to his discussion of the transfer patent, which is found on page 190 of the bundle, paragraph 232. In fact, if I could ask you to look at 232 down to 234, please.
Can we just read it for ourselves?
Yes, indeed, please. So the point the judge makes here is that there was a real-world physical effect external to the computer, namely the movement of the data onto the second device. In a sense, that makes sense. The exclusion relates to a computer program as such. And if that movement is fairly described as part of the contribution, it's very hard to describe a physical movement of data as being a computer program as such. It's a consequence of a computer program, but it's not a computer program as such. And as we've already seen, there was nothing inventive in that movement. It was standard, but that was no bar to avoiding the exclusion here.
Yeah, the pattern was invalid for other reasons.
Oh, yeah. I've resisted saying anything, my lord.
Waved on my heart, Mr. Shankfield.
But nor also was it an objection that the transfer was utterly subjective, because here it was the user who clicked on the EPG to choose the program. So that is that one. And then protecting kids, if I may, is in tab 9. And this was a case, just by way of background, this was a case concerning a computer program for, in effect, monitoring web browsing by children. And in the event of inappropriate web browsing, then alerting the parents or another relevant adult. The inventive concept was the use of a computer program which could sniff, as it's called, sniff data packets and compare the results of that to a sequence of what were termed hash tables, which were used to identify whether inappropriate internet access was occurring. And when this occurred, an alert message was sent to a remote device over the communications network. Now, the judge notes that alarms, and this is paragraph 25, but the judge notes that alarms of this type were generally known, but also held that because the monitoring process was more rapid and reliable, the alarms are also sent more rapidly and reliably. But note there that the rapidity and reliability was only due to the better process enacted by the computer program. So the judge cited the normal cases, Aerotel, Vicom, and then if I could pick it up at page 333, that looks like a terrible reference. Sorry, it's 226 of the bundle. And we've already looked at 31 and 32, where the judge concluded the sending of the alert message was part of the contribution. He differed from the hearing officer there. And in 33, he summarises the submissions of the UKIPO. And then, if I can invite you to read, just to start with the beginning part of 34, 5 lines down, where information was simply displayed on a screen. So he starts there by noting that the alert in itself was not a technical contribution because it was just the presentation of information to the user on a screen. And he refers there to that being 2 for the first 2 out of the 3 gem-style patterns, where again the information was just displayed on the screen. So an alert on a screen was not, he held, in that case, a sufficient external effect. But then he goes on to say, as he does, but what's in play in the present case is very different. And could I invite you to read through to the end, please? So in this section, he makes 2 points. The first is that there, what was in play was a physical movement of data, just as in the third pattern gemstone. And the second point he makes is that the claim as a whole can be viewed as a process for better monitoring the content of electronic communications, which is something he repeats in 35 as well. So protecting kids was a case where the judge put the technical effect in both ways, which we put it in 67A and B of our skeleton. reversing it, the order he puts it, he says invention can be properly characterised as a method of improving monitoring the internet. So that's our first class of technical effect. And he also says the sending of the remote alert message is part of the technical contribution of Claim 33, which provides a physical effect external to the computer. And so we say this is another case that clearly supports the two categorisations we've set out on our skeleton at 67A and 67B. And as I said, the logic of it is kind of simple. In this case, you may have some integers of the claim which are excluded, but others are not. And if the others aren't, then the claim as a whole is not within the exclusion. It's really as simple as that. And the language of technical effect that one uses is really, in my submission, just getting at that really quite simple proposition. So, unless you have any questions from those points, I wasn't proposing to address you on the foreign law point because it doesn't seem very, I put in the skeleton about the UPO, but I don't think it is important for today. I was going to address you then, in fact, fairly briefly, I hope, on ground 4 of my learned friend's appeal. So the first way we put our case is that the claimed invention in this case can fairly and properly be characterised as a system or a method for using a system for providing improved file recommendations. One can see that just by looking at the way the hearing officer accepted the way that we described the contribution. The first sentence is the invention of the application of the ANN-based system for providing improved file recommendations. And we say, well, that's accepted by all fronts. And we say, taking that aspect of the contribution, unless that itself is within excluded subject matter, and I deliberately raise that because I know my Lord Justice Arnold has raised questions along those lines, but unless that is itself excluded subject matter, then this claim is allowable under the kind of case that we characterised as 67A. Now, my learned friend addresses this in paragraph 52 of his skeleton. And the main points, the real points he makes in paragraph 55, apologies to jump around. Paragraph 55, so page 17 of his, internal page 17 of his skeleton. So there he advances his analysis which deconstructs the claim down to, as he puts it, the inventive contribution. But we say that that's just the wrong approach in law. I've covered that. You have to take the contribution as found by the hearing officer. And then second, in 56, he says the claim is excluded as the effect of producing the file is a subjective one, in that it induces happiness in the user. Now, our answer to that is actually, so what? The analysis that the ANN and the system performs is a technical analysis in the sense of it acts purely on the physical, in use I'm talking, purely on the physical characteristics of the various tracks. There is no subjectivity in that analysis. And the fact the user is happier because of its receipt is true of very, very many inventions. We mentioned some examples in our paragraph 22, improved massage machines, better car suspension, clearer audio equipment, improved audio codecs in communications. All of those are aimed to make the recipient happier, but that's not an objection under the Act. So neither of those are reasons why this claim does not have a technical effect. And subject to any questions that my lady and my lords might have, I wasn't proposing to say any more about that. This next point is the sending of the recommendation message. And it's important properly to identify the nature of this debate. It goes back to the mistake I made earlier with my Lord Justice Arnold, which you picked up on. One has to identify the contribution under Aerotel 2 and under Aerotel 3 decide whether it's technical. Now,
haven't you done that already?
Well, I've outlined it and I've dressed you on the law. If I can just pull it together, it's only a page. Because what we have in this case is a better system as a whole, which operates faster and more accurately than the prior art, and it sends a better recommendation message. And note the recommendation message itself is new in that it's faster and better, but it has a different information content to a prior art recommendation, save in the extremely unlikely corner case they both make the same recommendation.
That's true of any data processing system.
That it may be a common feature of a data processing system.
The fact that the informational content is new can't help you, can
Well,
it?
it's one of the it's a factor the court has to have regard to, and it's a factor that Mr. Justice Floyd had regard to in those paragraphs in Protecting Kids, as I showed my lord. Many cases, you may find there's cases, and this is why it's really important to distinguish in contribution and technical effect. You may have cases where there is an output message, but one just comes to the conclusion that the output message is arbitrary and essentially unrelated to the other integers of the claim. And you might just say, well, that's not part of the contribution. But that's not the case here, and we know that because the contribution, the message being part of the contribution is the last sentence in the passage in page 24 of the judgment. And more often, that is where, in my submission, this kind of debate is actually properly characterised. And that's also what Lord Justice Floyd did. He determined that the message was part of the contribution, and then he made the point, having decided it's part of the contribution, that it must be that it is a technical thing. It is not a computer program as such. It's an external transfer of data. So, drawing those threads together, we would submit, as the judge held, this is an entirely allowable claim under the Act. Much like Vicom, the front end receives a media file and subjects it to an analysis of its physical properties. And much like in Gemstar and Protecting Kids, the back end involves a transfer of data, and here the sending of, in parenthesis, fast, improved and new recommendation messages. Indeed, in a sense, this case is better than any of those three cases because it has the front-end interaction with a real-world file, like Vicom, but which Gemstar and Protecting Kids don't have. And it has the back-end message of the data transfer, which you see in Gemstar and Protecting Kids, but which Vicom lacks. Now, my learned friend makes a point in his skeleton about subjectivity, but I've already addressed my lady, my lords, on the subjectivity and why I say that's wrong. And I also note in Gemstar, as I said a moment ago, the transfer was truly subjective. The user clicked on the EPG to choose the program to send. And we say this case is essentially on all fours of Protecting Kids. So I've just said it was actually better than Protecting Kids, but the message is on all fours with Protecting Kids. The recommendation message in this case is sent more quickly from a more efficient system. The data content of the message is different and better than it would have been sent using the prior art. And it's a new and better message exactly of the type as Mr. Justice Floyd described the alert in Protecting Kids. Now, my learned friend sought also to try and create a bit of confusion, my submission completely unjustified confusion, by reference to paragraph 76 of the judgment. And can I ask you to pick that up? And starting on the top of page 108 of the bundle, the second line down, there's a sentence, the hearing officer seemed to consider. And apologize, I may just read it out so I'm not lost in what I'm talking about, just because it's difficult to navigate. It says, a hearing officer seemed to consider the subjective appreciation of the output system as just that, subjective and in the use, and therefore not a technical effect. I do not consider that to be the correct analysis. So there's the judge's recording, the hearing officer rejected the argument of technical effect on this subjective basis, and the judge disagreed. He then says the hearing officer was right to acknowledge that the result of the invention was an external effect external to the computer in the transmission of a chosen file. That is usefully analogous to the file that was moved in the third Gemstar patent. So his first point, he disagreed. So I can skip that. Then he says the correct view of what happens for these purposes is that a file has been identified, then moved because it fulfilled certain criteria. True it is those criteria are not technical criteria in the sense they can be described in purely technical terms, but they are criteria nonetheless, and the ANN has certainly gone about its analysis and selection in a technical way. It's not just any old file, it's a file identified as being semantically similar by the application of technical criteria which the system has worked out for itself. So the point the judge is making here is that the transmitted files are identified because they have physical characteristics which mean that they will be musically similar to the original file. Now the judge is of course correct to say it's not known how the ANN in fact links the physical properties of the track to its musical properties. One doesn't know that, and that's why he says those criteria cannot be described in purely technical terms. They can't be described in technical terms because one doesn't know at all what's going on within the device. But as he also points out, the ANN has gone about its analysis and selection in a technical way. In other words, by the application of objective analysis of purely physical features. And he likewise says the file has been identified as being semantically similar by the application of technical criteria the system has worked out for itself. And again, that's just a reference to the objective analysis of the physical features. Again, now all of that is a fair description of what is going on. And all that ties in with the judge's description of the application in paragraph 12, which we looked at earlier, but perhaps useful to remind oneself of what the judge said there. Because the key to all of it is that the analysis in question is of the physical properties of the tracks. And apologies, if I could just pick up two more points in paragraph 76, that's my error, and I do apologise for flitting around. Because what the judge then goes on to say is, so the output of a file is the output is of a file that would not otherwise be selected. That seems to me to be a technical effect outside of the computer for these purposes, and when coupled with the purpose and method of selection, it fulfills the requirement of technical effects in order to escape the exclusion. That's his finding there. I do not see why the possible subjective effect within the user's own non-artificial neural network should disqualify it for these purposes. This is correct. He's just saying the fact it makes somebody happy doesn't matter. And then he goes on to draw a comparison with protecting kids, which if you could read down to the end, I'd be grateful. So we submit that was an entirely correct analysis, and the judge was right to reach the conclusions, indeed for the reasons he gave. Now, my learned friend also referred to two EPO cases, a Yahoo case and the Stress Buildings case. And if I can pick these up, where we address them in our skeleton at paragraph 102.
What page is that?
It's 79 of the bundle, 79 of the bundle.
think we probably all read 102.
Sorry, I was waiting, so I didn't rush ahead myself. So this shows the danger of taking a single paragraph out of the context of decision as a whole, and if necessary, we can have a look at the decision. But the point in Yahoo is that there was a presentation or a recommendation on a screen. And as we've seen, recommendations on screens are difficult. They're not an external transfer of data. And the argument that was advanced there by the patentee was that there was a saving of energy in the computer because the better recommendation meant the user was less likely to submit another search to get a different recommendation. So the happier user, cognitively happier user, saved computing power because they didn't click for another option because they didn't like the one they were first given. And the court said that is not a technical effect. And in fact, they refer to it as a chain of technical effects. And they say the fact that the chain of technical effect from the presentation of the improved recommendation through to the actual user's head and the user's decision to click on a screen, which then led to less or more use of computation power by the submission of the later request for a song. That chain is an illegitimate one because it involves the thinking of the actual human and the actions of the actual human. And it's set out in that case, and it's particularly clearly set out in the 74108 case that is cited there. And if you wish, I can take you to them. But that case was very, very different because the patentee was asserting that the technical effect was due to the action of the human user in response to the presented information. It was nothing like this kind of case. And what's more, as I say here, if one digs into at the end of that paragraph, if one digs into the decision, 74108, it's pretty clear that normally an external transfer of data will be a technical effect. Because in that case, the main claims, the main request that's called, was rejected. But the patentee had an auxiliary request, which involved the sending of a bit of data, the details don't really matter, to a remote server, and then getting a response. And the TBA said, well, you're sending remote data. That's a technical effect. They then failed on obviousness, but that's just because it was obvious. So these cases, if anything, support our position because they underline that, in general, a transfer of data will be a technical effect. He also referred to the stressed buildings case, 156705, which we address in our 103. There again, it's really important to understand what the case was about. That was a case where the prior art included a computer system or a system which could analyse the stresses in walls and beams and lintels and things within a building design, so a proposed building. But the prior art did it in numerical terms and gave you a numerical list to look at, presented the numbers numerically, which isn't very intuitive, particularly if you're not an engineer. The invention was to essentially convert that into a colour-coded presentation. So you had your picture of the building, and instead of having a list of numbers, you had some bits were red where there was a risk, and you had other bits were green or blue, which showed that they were more stable. The patentee in that case sought to argue that there was something technical in the choice of colour coding because that made it more applicable to a particular class of person, which was non-engineers. Engineers like numbers, they said, and non-engineers didn't like numbers. And in the passage my learned friend cites, all the TBA is saying is a presentation of information is excluded, and choosing a presentation of information just to relate to a particular class of persons is equally excluded. That's all that case is a proposition for. So the last point is about the presence of the ANN itself. This is paragraph 78 of the judgment. And I'd like to explain it so my lady and my lords understand what the judge was addressing here. in fact, it probably doesn't really matter for the present appeal, but I don't want it to be suggested that the judge was going a bit off-piste, as my learned friend was trying to give the impression. What the judge sets out in paragraph 77 is saying, look, even if maybe I could even take a step back. Before the judge, the main way that the argument was put by the UKIPO was to say that the training process itself was computer-based, and that, as it were, infected or resulted in the invalidity of the whole claim. And that was tied in with their, what I say is, incorrect contribution approach, because they said that was the inventive bit and therefore focused on. In 77, the judge is saying, even if that's right, and what is key, or even if I accept the UKIPO's case, that what really matters is the training program. And that's why he talks about the training program or overall training activity on line 4. He then goes and says, well, even if that was right, if contrary to his findings, it doesn't matter. Because if you're just saying the claim is liable to be excluded because of the training program itself, the ANN produced by that training is a technical thing. And that's similar to how my Lord Justice Birss looked at things in Halliburton, where you considered the design of the drill bit itself as being a concrete technical thing. So that's what all the judge was saying here is, even if he's wrong and the training process is a relevant computer program, then that doesn't invalidate the claim as a whole, because the ANN itself is a concrete thing which results out of that process. And it's long been the law that the fact that a computer is used to design something doesn't mean that that thing itself is therefore a computer program or a program as such. Now, before this court, the focus is not on the training program. The focus has shifted very much to the ANN itself. And that's why I say this probably doesn't really matter given the way the case has been developed for my lady and my lords. But I just wanted to explain it because I didn't want it to be thought that the judge was doing anything particularly off-beam or unusual here. You just have to understand that this was an argument advanced in the context of the way the case was put before him. I think that then takes us to mathematical exclusions. My learned friend has addressed this very briefly, and we have done likewise. It's set out, our position is set out in paragraph 110 of our skeleton, which is 81 of the bundle. Now, the point is a short one. Our case, which the judge accepted, was that an ANN at the level at which it's claimed in the invention is a thing. It's a structure of links and nodes and weights and biases. Of course, it could be implemented in various ways, but that's what the claim is to, and it's used for a particular purpose. And we say it's not within the mathematical exclusion for a number of reasons. First, an ANN is not a mathematical method. Now, it can be described, at least theoretically, mathematically, but that is true for almost every invention in the field of engineering and electronics. It's obviously true, well, it's even true for many inventions in the field of pure mechanics. You can describe mathematically the movement of a section of cogs and cams and cutting blades, for trimming paper, for example. But the fact that something can be described mathematically does not make it a mathematical method as such. But second, even if we're wrong about that, the law both here and in the EPO is that this exclusion only bites on abstract maths, not to claims directed to practical application of mathematical algorithms or mathematical methods. And we saw that in Vicom, that's what I showed my lord that bit. My lord considered this in Halliburton. I'm afraid I haven't had a chance to show you that, but in Halliburton, my lord came to the same conclusion, which is that a practical application of a mathematical concept is outside the exclusion, a narrow exclusion. And in paragraph 110, we also refer to the case law, but I don't think I need to show you that.
Well, what do you say about the Mitsubishi case in the EPO? Because there, they looked at both the computer program exclusion and the mathematical method exclusion, but they focused more on the mathematical method exclusion, and they said that an ANN was excluded by it.
Sure.
So do you say they're wrong?
Well, not on the facts of the ANN of the Mitsubishi case. And like all these cases, one has to look at the details of that case. So we addressed it in our skeleton at 108. And the thing one, it's page 8 of the bundle. Now the thing about the ANN in Mitsubishi, that was a case which involved an invention relating to the manner in which one, in fact, trims out, I think it was links rather than nodes, but trims out part of the structure of an ANN during training. And the claim was just to the process of trimming. It wasn't linked to any actual real-world application of that ANN. It wasn't used for an ANN for canning soup, recommending music, or anything like that. And that's why it gets described as abstract and untethered. And one of the things you have to bear in mind, as we say here, is that when you have a completely abstract machine, or abstract claim, it has at least two problems. One of them, it might be said to be arbitrary, and so fall within aggrevo type objections. And the other one is it can cover excluded subject matter. So you could use the ANN of Mitsubishi, for example, for classifying loan applications for the purpose of making decisions to give loans. And that's, paradigmatically a business method exclusion. So, but the problem here is it was just completely untethered. I see my lord getting it out. If I take you to that, it's tab 21. So my lord will see, well, the claim is very long. It's found on 502 through to 500, well, just the top of 504 of the bundle. And you see at 3, the examining division argued that these distinguishing features do not serve a technical purpose. They're not related to a specific technical information. They merely pertain to initial fixed structural definition of an abstract mathematical method, etc. So that's the point I was making, is that this was completely untethered.
The argument was it was a better computer. The argument was it was a better ANN. So look at paragraph 4.3, for example. This is reciting the appellant's arguments. They say the distinguishing feature solved the problem of improving the learning capability and efficiency of a machine by reducing the required computational resources and preventing overfitting. So this was the argument was it was a better computer type of case, to which the answer given by the Board of Appeal was this is just better mathematics.
Yes, but the point they make in 11.3, they say whether claim invention compatible or not can often be decided by focusing on the technical problem it solves and by means of the combination of features, etc. So they're going back to the point they make there is one has to focus on the technical system, the use of the invention within a particular technical problem. And the problem with this case is there was no technical problem at all.
Well, again, as always with these, it depends what you mean by technical. So if you look at paragraph 12, they're prepared to accept that the neural network has a new and novel and obvious structure. So in that sense, there was something technically new. The problem was that all it was doing was improving the mathematics.
Well, yeah, well, if one looks at paragraph 19, which is the conclusion, the board says the claim as a whole specifies abstract computer implemented mathematical operation on unspecified data. So So the point they're making there is, again, that it's not related to any particular data. It doesn't have any particular technical purpose, or any purpose at all, technical or not. So it's an untethered application. And you see it further, oh sorry, yeah, 20. And so when one looks at 20, you have to look at 19, paragraph 19 in the concept of 20, where it says the board stresses that there can be no reasonable doubt that neural networks can provide technical tools useful for automating human tasks or solving technical problems. In most cases, however, this requires them to be sufficiently specified, etc. But the first sentence there is really important because they're saying absolutely, ANNs can often be claimable as long as they provide a technical tool solving a technical problem, or they talk, sometimes automating human tasks is described as being a technical effect in itself. So it depends on what the task is, I would say. But the first sentence of paragraph 20 is exactly in our favour. It's saying that often they will be technical things. Sure, you have to look at the facts, but the problem with this one is that it had no technical application. It was just an untethered conceptual invention.
I think we've got it.
And so the last point then, I think, is if one looks at, sorry, can I just ask my lady, my lords, to tab 25, page 557, to take up the EPO guidelines again. So it's 557 of the bundle. And just to read the last paragraph there.
I'm sorry, that page again?
557. And it's particularly the paragraph, in the first paragraph and the third paragraph. Because the first paragraph makes the points we were just discussing, that applications in field of technology, artificial intelligence will often have applications in fields of technology. And then the classification of images, videos, audio, or speech signals based on low-level features are further typical technical applications of classification algorithms. Now, strictly, the ANN in this case isn't a classification algorithm, it's a sort of a classification plus plus, it's an improvement over a classification. The point being made here is that typically an analysis of the low-level features of inter alia music files, which could be rhythm, tonality, etc., that you see, are further examples of technical applications which are acceptable. So our case is consistent with how it's put in the EPO guidelines. So unless there are any further questions.
No, thank you very much indeed. Eustace, do you follow?
No, I don't.
Thank you very much. Mr. Nicholson.
My lady, my lords, I've got a limited number of points. A limited number of points, and I'll take them in the order that they arose in my learned friend submission, which is slightly sort of random spotting.
That's all right, but just do it point by point.
I will do, thank you. So my first point is addressing the many criticisms my learned friend made throughout his submissions as to the correct test for contribution, drawing a distinction between the old test in Merrill Lynch and the new test picked up from Genentech and followed through in Aerotel. And we completely understand the difference. The problem with the old test is by reducing the contribution to only that which is inventive before turning to the issue of the exclusion, you potentially exclude technical but non-inventive features of the claim which might take the claim outside of being a computer program as such. The distinction between that and the approach now following Aerotel in particular is that you look at the whole of the claim, you identify the actual contribution, not specifically having regard to the patentee's inventive step, and then you do the analysis for excluded subject matter and then look to see whether what's remaining is technical. We understand that completely. It is slightly nuanced in that the Aerotel question that my learned friend was looking at with my lady and my lords includes the aspect of what has the patentee or applicant added to human knowledge. So you always end up with a slight eye on where the guts of the patentee's contribution lies. And what my learned friend is doing when he makes complaint throughout my skeleton is pointing at any paragraph which suggests elements of this are old, they're not really the focus. But all of this is irrelevant. And why it's irrelevant is because I haven't started with an actual contribution of my own. I haven't wrongly approached the Merrill Lynch, the old test approach, and written out an actual contribution that misses things. And indeed, my learned friend doesn't say that anything's been missed. What we have started with is the actual contribution advanced by the applicant before the hearing officer, maintained before Sir Anthony Mann, and brought forward in this court. And as I explained to my lady and my lords earlier, and my learned friend really doesn't address, is that the reason that overall actual contribution, only the middle section of which, the training, is part of his invention as such, his inventive validating feature over prior art. The reason that becomes decimated down by the time you get to the final Aerotel question is because the other aspects of it have been removed as excluded subject matter. And I showed how the hearing officer had gone through and done that. So in fact, all of the concerns about contribution in the old test and the new test, it really is rather a red herring. It's a convenient point at this stage to pick up a slightly separate point, but it comes under the heading of where my learned friend ended up on VICOM. And VICOM, as my lady and my lords will recall, is the image processing software. You put a picture in, you get a better picture out. And the difference between what's going on in VICOM and what is going on in claim in the patent application before the court is one can look at the output file in VICOM and say, is this technically better? Is it, as my Lord Justice Arnold characterised it, is it a sharper picture? That is technically improved. And the fact that a computer and computer algorithms and potentially mathematical methods have been involved in that process is irrelevant because the output file has technical character. That's completely different to what comes out of the claim in this case, where all you have is the precisely identical sampled musical file that was existing in the database before the invention even started to operate. There is no technical improvement in the file itself. There is no technical contribution. The second point I make is in respect of the application. And my learned friends, as my lady observed, were indicating informally that they had great disagreement with me as to the teaching of the application during the course of my submissions yesterday afternoon. And it does matter what my learned friend says that we agree or don't agree with, what he's pointed out that we've got wrong. At the end of his section on the application, he came down to 4 points. His first point was the process does not converge semantic and property space themselves. They don't necessarily represent each other. They can be, they're not identical. They're representatives rather than the space itself. I don't disagree with him. I didn't intend to suggest otherwise. It is irrelevant. Secondly, he says that the ANN is, the ANN is not making any judgment itself about musical semantics. Even the NLP, the natural language processing, is just analysing words in a technical way. I don't disagree with him. I didn't intend to suggest otherwise. There's no problem going forward. Thirdly, he said an ANN has a structure that's different to any other ANN. It's a different structure than ANN. And the point he picked up slightly later is that in the course of training an ANN, in some implementations, it is possible to include techniques such as that which Professor Pardo described as pruning. I didn't address the course specifically on pruning. I accept that. The process is very simple. If during the training exercise you notice the weights of all the weights of a particular neuron going to zero, then you let them be zero, and you don't have to worry about that neuron thereafter. It's a difference on the basic training of neural networks, particularly when you're doing a software emulation. It saves you having to work with that neuron. In a hardware arrangement, the neuron's still there. It just has all of its weights set to zero. But it changes nothing about the set of weights and biases and eliminated neurons, if you want to add that to the end of the list. It makes no difference to the dispute between the parties. And then finally, the fourth point my learned friend made at this stage when discussing the application was a human doesn't prescribe how the ANN goes about its analysis. And this was a laydown for the point my learned friend was making later, which is one of the key things about instructions is they have to be written by a human. And that wasn't pressed by my learned friend. So insofar as it was a point which wasn't made clear in the context of the application, it falls away for the same reason. So as I say, one is trying to work through some quite complicated technology and seeking as conveniently as one possibly can to ensure that this court is properly informed as to the subject of the application. Despite all the shouting and screaming, there was nothing in my learned friend's submissions that say that anything materially wrong was presented to the court. An additional point which came and went, this is my third point, my lady and my lords, that was made was a pickup about when going through the hearing officer's material that part of the benefit system is it's faster than the prior art. We struggle with this to some extent. We say it makes no sense because we recognise this faster than the prior art contention in the context of those cases which lead to a better computer. So by changing effectively the structure of the computer, one ends up with a faster and more efficient computer, and it's better than in that sense. In the particular case, however you look at it, because this is a patent which says it gives a different result to all of the prior art, there can't ever be any comparing apples with apples. If the result that's coming out is different, what is it faster than? There is no comparison.
Is it fair to say the hearing officer did accept the definition in paragraph 53, which had the word swiftly in it?
He did, my lord. I can't move away from that. It was one of those points where, as is so often the case in effectively ex parte prosecution of patents, if the patentee wants to say it's faster, then
swiftly is fast, not faster. Because faster, as you say, implies a comparison. Then you have to say comparison with what? Faster than what?
Well, so if my learned friend is saying that this is better an improvement, he hasn't got a metric. Insofar as he's saying it's swift and great, then that's what patentees say, and there you go. My fourth point, which I could spend time on, but I'm going to try and do it very...
Mr. Nicola, that's a little unkind, isn't it? I mean, the hearing officer did say, not just that that is what the applicant says, he held that this is a fair way of putting the contribution. I mean, are you going behind that?
Well, I don't go behind it being I don't go behind what the hearing officer said. That certainly artificial neural networks work swiftly. That's one of the aspects of their technology. But the question is, it's not a technical improvement on anything in a way which would justify circumventing the exclusion. And my learned friend didn't come back and sort of seek to rely on it in that way, but he did press upon.
It might be worth looking at what the hearing officer says at 54, which is what my lord was putting to you, where he says it's a fair way of putting the contribution. And he goes on to say, and this is what I was asking Mr. Chagsfield about, reference to accuracy captures the system is better at identifying and recommending files to the user based on semantic similarity. So that's the point we've been over about semantic, or in my terms, aesthetic, and it being better in that dimension. It's not about this is faster.
Quite. That's the point I make. And the semantics or emotional or aesthetic point is the one that we've been debating for the last day and a half, and was the focus of everyone's attention before Sir Anthony Mann. My fourth point is computer and computer program. There's relatively little I need to pick up from what my learned friend says. It is certainly true that computer is a broader term than simply computer program, because as my Lord Justice Birss made clear, computer has actually been used for a term for humans going back to the teams of people who worked calculating materials for space missions and things and the like at NASA. We've also got a somewhat esoteric discussion about whether or not computer in its broadest sense would include matters such as slide rules and sextants and things of that nature. All of those prior and broader uses are different from the programmed computer. And the programmed computer is the one that operates with, I'll use the term that's around the set of instructions or the program. And of course we are somewhat eased in this respect in that the Article 52 and the Patents Act both refer to computer or program for a computer, so we know that's what we need to focus our attention on. And insofar as computer needs to be understood to give meaning to program for computer, then computer is implicitly that subset of programmed or programmable computers. But beyond that, I don't think there's anything I specifically need to pick up on my learned friend's discussions on that topic. So that brings...
I'm afraid I'm going to ask you a question which I know might set a hair running, but it occurred to me and I think it might matter. The word algorithm is used quite a lot in the context of machine learning.
Yes.
And as I understand it, but please tell me if I've got this wrong, the algorithm, which people are referring to, is a way of saying in a word what it is which turns the input to the trained ANN into the output. Is that right? It's a description of I mean, that's what you're saying when you refer to the algorithm in that context.
There are a number of times at which the algorithm is used. The most common one is, I think, something like the back propagation algorithm, which which is
Well, I understand.
which is all about the process above and forward. It wouldn't be, in my submissions, it wouldn't be inconsistent to talk about the ANN's algorithm, which I think is the way my Lord Justice Birss is referring to refer to what is being processed between the input so as to generate the output. Because as my lady and my lords will have understood by now, as you use these neural networks in practice, you often show them a piece of data, you present it at the input, and then the algorithm goes through the process of calculating the input nodes, then down to the first hidden layer, then down to the second. So there's an algorithmic nature.
And that's precisely why we see in cases like Mitsubishi the proposition that at a high level of generality, an ANN is a mathematical model.
Yeah.
And then the question is, what are you using it for?
Absolutely, my lord. So that brings me to my fifth point, and this is where my learned friend says that no one looks at artificial neural networks in the structure and weights and biases way that the comptroller has presented matters before this court. We say that isn't the case. I've only got limited materials before the court to address that contention. An important one is Mitsubishi itself, which is in the authorities bundle at 21. And I really point, my lady and my lords, to the discussion starting on page 508, providing technical background of neural networks that runs through from paragraph 7 through the points all the way up to paragraph 8. We say that it's not a specific point I'm pointing at, but if one looks at the way in which the EPO is presenting it, it's consistent with the submissions that have been made to this court by my side. And if I point to anything specifically, I would say 7.3. Each set of weights defines a different such function. Thus, neural networks with particular structure constitute a class of mathematical functions, and each member of the class is defined by its weights. So, again, they aren't directly drawing their attention to it there, but the distinction between the function and then the set of weights defining each individual member of the class. We see that in routine discussion in the EPO. And for my lady and my lord's note, I won't go to it because my learned friend just did. In Authorities 25, the EPO guidelines, page 557, and section 3.3.1, producing a background to artificial neural networks, is equally consistent with the submissions which I've made.
What do you say about the passage that Mr. Shaxfield referred us to on page 557, since we're there, in the last paragraph on that page? The last paragraph on 557, which I think it's the third sentence. It starts in the middle of the paragraph, 4 lines down. The classification of digital images, are further typical technical applications of classification algorithms. Agree with that?
Yes, because the comptroller doesn't deny, and never has, that artificial neural networks are technical, that they are used for tasks such as classification algorithms, be they edges of pixels, features of that nature. That's what artificial neural networks do. That doesn't, and I can say the same of a conventional computer. Conventional computers routinely use technical metrics to select the data that the user wants, to provide search algorithms, and to provide useful outputs.
Yeah, so the obvious example here is facial recognition systems. You use an ANN that looks at pixel attributes to recognize human beings' faces. That's a classification exercise, because what you are doing is you're classifying the images into those which are, first of all, images of human beings as opposed to animals, for example. And next you classify into male or female, you classify down and down and down, and you end up hopefully identifying your target.
Yes, and depending on how far you want to go, sometimes you can get so far that you can use them for security applications, whereby myself and only myself can unlock my iPhone or other leading smartphone. Or you can do it really quite poorly. My lady and my lords might recall back probably 20 years or so ago, digital cameras were starting to put the viewfinder in a little box in the image, that this is where the face is of the person to make it the focus point. That was well before the days of artificial neural networks, and it does show that, or practical deployment of artificial neural networks, and what it does show is that some of these tasks that are done today to a very high quality with neural networks can also be done in a more basic way, perhaps with not so good results, by conventional computers. And what one's looking for in these systems is there's nothing special about the neural networks as opposed to conventional computers. They're all excluded by the exemption unless and until you show the necessary technical contribution.
By reference to the end result, which is the technical problem you've solved.
Exactly.
Well, that's exactly why I wanted to put this to you, Mr. Nicholson, because as I read this sentence, well, first of all, I think this is right, but please tell me if I've got this wrong. The point of this paragraph is to talk about technical applications which an otherwise unpatentable thing would qualify as being something that's an application in various fields of technology. That's what this is about. I think that's right. And then in the sentence I'm drawing to your attention, I hadn't noticed it until listening to this discussion. What it's talking about is not based on the output, but based on the input, based on low-level features, e.g. edges or pixel attributes, are further typical technical applications of the classification algorithms. So just explain, if I've misunderstood it, please tell me, and if I haven't misunderstood it, tell me why that doesn't apply in this case.
My lord, as I understand these early paragraphs of this section, is they're actually really introducing and categorizing what artificial intelligence and machine learning techniques are and the sort of results to which they can be put. What we see here is lists, but we don't see authorities. That comes over the page, for example, at the top, where classifying text documents, etc., and classifiers may be considered to have a valuable mathematical properties and robustness. And then we get the actual authority. I'm not.
That sounds like a polite way of saying you're saying it's not actually accurate.
No, that it's not that it's.
Okay.
It's not that it's not accurate. I'm saying that the purpose of these sections in the general guidelines for examination of the UKIPO, identifying the sort of technology that we're talking about. So it starts 2 lines into that paragraph. For example, the use of neural networks in a heart monitoring apparatus for the purpose of identifying irregular heartbeats. There it's saying that particular one makes a technical contribution.
Yeah. So you would draw attention also to the second paragraph at the top of 558, where a classification method serves a technical purpose.
Yes.
And so on. So, as I was suggesting, your submission, as I understand it, is you look at the purpose, classification for a technical purpose.
Yeah.
Of course.
Absolutely. And this isn't intended to say that, e.g., anything that does edges or pixels attributes for an image will be straight through the exemption. It's a much more general discussion than that. My sixth point arises in the context of my learned friend's self-contained discussion of ground 4 towards the end of the afternoon. And slightly surprisingly, I understood my learned friend to be saying that when he says a better file recommendation, he does mean in the aesthetic sense, but he says that the point is irrelevant, that there is better files for an aesthetic purpose. Now, if I understood that correctly, he really is down to, I provide a song to a user. No attempt to rely on aesthetics at all. And one can understand why he doesn't want to try and rely on better in the aesthetic sense. But if he has literally come down to it being the provision of a file, this is the same with just any data retrieval process. Could be being done in any way at all, and unsurprisingly you get a file out. We say that is classically not a technical contribution. In GemStar, in the same section, my learned friend sought to say that the result in GemStar was truly subjective because the user selected what they wanted. But that isn't the objective, to use the opposite term, or the technical output from the system. The user keys in what they want, and in response to that, after relevant processing in accordance with the invention, the output signal technically gives the user what they've asked for. So there's no good saying that the output is subjective because the request is subjective. That is not looking at it in the right way. It isn't a case of the user saying that they want something and the algorithm or the system saying, try this, which is what comes out in the claimed invention. And then the final point, my 7th point in reply, is just picks up on the mathematical method. My learned friend's submissions in effect came down to looking at mathematical methods and saying there isn't the established law is that there isn't a out-and-out bar on any claim which involves a mathematical method. And as such, the same as the computer or program for a computer exception. Of course, we completely agree. And it therefore follows, as he showed my lady and my lords with reference to various authorities, that there are times when a mathematical method can be claimed, or rather, a claim involving, in part, a mathematical method can be claimed. But the test is the same. The test is we've got to find the technical contribution elsewhere. And what my learned friend overlooked is that really the only way that the mathematical method ground is running in this case, on this appeal, as it did before the hearing officer, and as the comptroller tried to introduce it in the submissions after judgment before Sir Anthony Mann, it only arises if my learned friends say, circle round the neural network isn't a computer program, it's technical and that gets me home. Then you've got to look at it and you've got to do the same process of, okay, so it's a mathematical method, but we've still got to look at the claim as a whole to find that technical contribution. So I didn't find anything beyond that to address in my learned friend's mathematical method exclusion. My lady and my lords, those are the points I identified from my learned friend's speech, but if there's any other questions.
No, Mr. Nicholson, thank you very much indeed. Very grateful.
Great.
If your permission to make one reference, please, it is very, very short, which is faster than the prior art is the hearing office decision, paragraph 49, just on the debate that has been.
Thanks very much indeed. Well, can I begin by saying we are very conscious of the sheer amount of work which has gone into the preparation of this appeal, not simply by those who are sitting in the front row, but those who are working in other rows, no doubt outside this courtroom, and we are extremely grateful. It doesn't need me to say this judgment is going to be reserved. It is. We are conscious of the importance of it, and when the judgments are drafted, they will be circulated in the usual way. You will all be familiar with the embargo and the words in respect of contempt in the Counsel-General of Wales case, and that is the basis on which the circulation will take place. It is there for the correction of typographical errors. It is not there for any re-arguing of the case. But again, let me conclude. Thank you all very much indeed for the considerable assistance you have each given to this court.
All right,